Everyone, welcome to the Virginia Gas and Oil Board hearings. That August 19th, 2025. On the Virginia Energy Keystone Gas Office. I'd ask everyone to please silence your cell phones. These meetings are being recorded. If you need to take powers, then please go outside of the hallway, please. I do have one person who signed up for public comment. We'll still be here today. If there's anyone else who's interested in public comment, about signing in, this is your opportunity to sign the bill.
Good morning.
Yes, you want to make the announcement first?
Yes, I will. I just want to make an announcement this morning. Mark Mullins has been appointed to the board to fill one of the vacancies. We still have one seat vacant. It's not filled yet. It's in the process of being filled. So I just want to let you know we got a new member left in the board. And also Gus Jensen is now officially been designated chairman of the board. So thank you, everybody. Welcome board, Martin.
Thank you. And at this time, we'll have everyone on the board please introduce themselves.
Patrick Owens, public member.
I'm Bill Harris, a public member.
That's Jameson, I'm a public member and also chairman of the board.
Lawton Mullins, industry representative.
Mary Gibson, public member. Willie Cochran, Virginia Energy.
On the call, the vote for you, make sure you're muted. We've got two guys coming back in here. Thank you. To be with item one on the docket, the board will review and approve the remote attendance resolution for any board member that is attending remotely. Today, I don't believe we have any remote members. We'll move on to item number 2. Board will receive public comments. We have one person who signed up for comments. It's Mr. Ms. Cole, come forward and speak.
May I go ahead?
Uh,
This is Mark Stuckey. May I go ahead with a comment?
Just a minute, Mr. We have one person here locally that's going to go first.
Oh, I'm sorry. I have signed up too with Sarah, so I'll wait.
And Bill.
Just state your name and
Paul Coleman. I'm NJ Cole here. The last call. And we were getting relief this to some other company and they sold out the summer. The summer started putting all this money in escrow. I'm just trying to find out how come it's going in escrow.
so you're the company, who were you dealing with before some of that production was operating?
Yeah, they sold out without bidding stuff. We never did know nothing about it. You know, I was working for Summit. I asked him if there was where. He said, yeah, I'll go to Summit. They told me I said, well, I was in Texas. Yeah, no. He said it was put in there with a confusion or something. I don't know. It's a gas board stuff put it in. And I just trying to find out why they put it in there.
Mr. Cole, you may be interested in docket item number 5 today. It's a petition for diversified production, the transfer of the rights of Summit Appalachian. Their new company is part of that company. I don't know if there's anybody here that wants to speak with Mr. Cole out of the hallway about this situation, but you may want to hear that. And if you want to come forward at that time and ask me a question during that, you may be able to do that. Thank you. Okay, Mr. Stuckey, if you want to make your public comment now, and you're
Thank
also
you.
on the docket, you'll be on the next item on the docket also, if you want to be involved with that part of the hearing.
Yep. I'm here for that. First of all, I'm speaking in opposition to Key Rock's proposed AFE revision to the Honey Camp number 1 well from $186,000 to $2,186,000. I also speak for my brother who owns a 0.55% interest and I own a 1.1% interest. I have to say I was flabbergasted to have received this revision only yesterday. I believe that it subverts and circumvents the Gas and Oil Board's process for pooling. That process is about adequate notice, full disclosure, and fair options for mineral owners to receive value for their land. This proposal does none of these. The notice was inadequate. As I said, I just learned of this yesterday. Disclosure was non-existent. How did costs increase 11x? And the AFE effectively makes it impossible for me to participate in this as a working interest owner. This proposal, this revision clearly undermines the entire purpose of the pooling process. And I think the board should be very concerned about the way this is being introduced. I would point out that the AFE classifies $1.7 million in consulting type costs as intangible drilling costs. I spent the first 9 years of my career in financial analysis for a major oil company, and I do not believe that these costs would qualify as IDCs. I am also certain that if an operating partner sent us an AFE with these expenses, we would have rejected it outright. Furthermore, I have to emphasize that this well is already drilled and producing. In the original pooling in February 2024, the AFE was for $178,000. This was before drilling, and you approved that pooling. In July, repooling, the AFE, having the benefit of actual expenses, was for $186,000. Now we have $2.2 million. How can this be? I have even had discussions with Key Rock earlier when we talked about the cost of this well, and nothing of this magnitude came up. I came to last month's meeting, you may recall, seeking your assistance to be a participating operator in this unit, as I did not feel that Key Rock was really interested in having me as a working interest owner, and they were not going to embrace that concept. I again seek your assistance. However, I think there's a bigger problem than just the AFE. Even if the AFE is adjusted to a reasonable number, how can I be confident that Key Rock will fairly report costs on an operating basis? And what about capital calls? It seems to me that their MO is to pile as many costs on a working interest owner that they possibly can. How can I be protected? Can you require that operating statements and capital calls receive a third-party audit at Key Rock's expense? This is a conundrum, I think, that's difficult to resolve without me being bought out. I also believe that if this behavior is as it appears, the board should consider whether Key Rock should be considered a responsible operator. If their approach is to subvert and circumvent your rules, should you grant further poolings? To conclude, I get it that Key Rock doesn't want me to be a participating operator. They don't want to deal with me, although I'm not a bad guy. I submit that the way for them to do this is to buy me out and buy my brother out at a fair price, and not to force us to take a royalty interest or to expropriate our asset. Thank you for listening.
Thank you, Mr. Dickey. And again, we're going to be hearing this item 3, and you're welcome to participate in that also.
Thank you.
Item number 3 on the docket. Key Rock Energy LLC will report to the board the reasons made as AFE regarding unit Honeycamp number 1, docket number PZOB 22-1219-4279-01. This docket item was previously approved at July 25 meeting. Mr. All parties come forward and will speak to this matter.
Tim Scott, Aaron Davis for Key Rock Energy LLC.
Mr. Stuckey, will you be speaking here also?
I'm sorry.
Will you be speaking again also? You have. the right
Well,
to-
I might make a response, sir. I have nothing else to say. I believe I sent you a letter as well.
You did, thank you. Okay, Ms. Gill, will you swear in Witness to that.
Mr. Davis, do you swear and affirm that your testimony is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Do it again.
Thank you. Mr. Davis, please state your name and what your job responsibilities are with you are.
Aaron Davis, same green, engineer with Key Rock.
How long have you done this for you are?
Been here about 3 years.
You familiar with this application?
Yes.
And there was an AFE originally submitted with this pool into place, is that correct?
That's correct.
And the original AFE directly reflects the cost of drilling this well.
Upon review, determined the items not included in the original AFE. Accurately reflect cost. Accurate.
Can you please tell the board what those items would be?
There were pretty obvious tangible items that is such as we're in the construction business. I can notice on the painful section of the AFE, no destruction devices have previously been shown. So if anybody were to visit the site, they can see these destruction devices. The flares are 30+ feet high. There are 3 of them on site. In addition to that, there's trailer unit, instrumentation unit, which contains for the range of operation, analyzer, flow meters, and things of that sort, and a blower, which effectively applies a negative pressure to rate the gas flow from construction. None of those things were included. They had all been inadvertently omitted.
Can you point out to the board where they're located are now shown in the section of the AFE?
They are in the middle of the intent or angel section. Here's bottom page. This is the flares, asset numbers, lower trailer wheel. They're in the middle there. At the bottom.
So beginning with 48,000, 47,000, 47,075.
That is correct. Correct.
So those are now included in the base fee.
Correct.
And once you determined that the AFE that was submitted was incorrect, did you advise the director that you would submit your revised AFE?
Yes, I did.
And have these items been previously omitted from AFE submitted by QRON?
Yes, they have. My knowledge, these destruction devices have never been included. So with the closer look at what items have been omitted, that's the realize that tangible costs had also been omitted from inadvertently from this AFE.
So you didn't prepare the revised AFE, is that correct?
That's correct.
And determining what items would be included, what were your guidelines for determining what would be included on the revised AFE?
The Virginia Administrative Code, Title 4, Chapter 160, Section 100.
And did you follow this regulation in preparing the AFE?
Yes.
Those items. So the other question I have is, Mr. Stuckey had previously stated that he was not advised of this hearing. Did you send a certified letter to him?
So it is.
And that was done as soon as you realized that it would be here. Is that correct?
That is correct.
So that was sent according to the affidavit that was sent to filed with the board. I believe it's August 11th. Is that right?
That is correct.
And you did contact Mr. Stuckey yesterday. Is that correct?
With an email, yes.
Yeah, because there was a problem with the mail. Is that right?
I suppose so, because it was mailed, it's actually mailed August 6th. I have personally out here, August 6th, and
So we have filed an affidavit name. Correct.
correct.
Were there any other parties listed on the D3 came forward during the July?
No,
So in your opinion, does AFE now accurately reflects the cost for this well? Is that right?
that's correct.
That's all I have from this survey.
Questions for the board? You've explained probably $1.6 million for the fees of these companies. Not there,
Those fees were provided to me for environmental engineering fees, consulting, financial consulting, there was some transportation costs for aircraft flying into on some time. Airport, things that went along with the rail. Teacher that, you know,
Mr. Chairman, is that not considered the cost of doing business for the other folks rather than you? I mean, this is, I guess one of my concerns in this and other projects is that we're gonna start seeing revised AFEs with 10 times where we, and I mean, facetious by saying that, 10 times what we used.
So, this board wears first, AFE that I had prepared myself was, this original AFE. Previously, my predecessor, along with our company, taking care of things. I didn't want to reinvent the wheel, so I used, kind of what had been used and submitted in the past. I used that as, I didn't know any better. These are some I thought I'm to blame. We did certain things, including, you know, consulting costs, but also the tangible items that anybody were to drive by on the side. It would be impossible to miss through 30-foot plus stacks extending into the sky. They had been omitted. My knowledge from every AFE that T-Rock had ever tendered.
Yeah, these are flare stacks.
Yes, flare stacks, yeah.
But those are part of this.
Absolutely. Yeah, well, that's all part of the fire process.
They're obviously not impossible in this because I'm just, while you were talking, I've been going back to previous petitions and we've missed them over and over. So I guess more to Mr. Harrison's point, are we going to start seeing revised AFEs on all of the old ones that have already been done?
Yeah. Well, when I said it'd be impossible to go to the site and visit the site and miss these stacks, then clearly they have been omitted in previous application.
I believe
Could I-
it's like to submit, since this is a little fresh, I don't believe there's going to be, there'll be any additional revised AFEs submitted to the board. Is that correct? Correct.
And let me
Sirs,
ask-
may I interject? I'm sorry, may I interject? I just want to say I have no objection to the capital items, you know, the flares, that's fine. I understand those are part of the project. It's the $1.7 million in, you know, supposed IDCs, which are put in there with very round numbers with no documentation and which account for 80% of this increase. That is the question. And I do not believe that Key Rock could have a profitable business if their wells cost $2 million like this. So I question the whole premise. Sorry. Thank you.
thank you, Mr. Stephen. We'll continue with our question here.
I just had a quick repeat of the cost for doing business. We have people flying in, and so is that normally charged? The projects, when you have that?
That's my understanding. And those costs are allocated projects.
Just a couple other questions here. If I remember correctly, when we first started hearing these applications with carbon credits, I believe it was pointedly asked if you would include any of the equipment costs or the flaring costs, and it was stated at that time, no, we're not going to include those. QROC was not going to include those costs as part of their AFE to be passed on to the landowners. Now you're including them. So what changed that position?
I'm unable to say what my predecessor had served.
Well, we need to have people here that can address these issues if we're going to make any changes. Say, here's one thing. Yeah, the other costs that are up here, there's $1 million cost in here. Are those costs that have been incurred on each of the units that QROC has developed to this point, and all the other units are doing? placed in the service.
Well, I believe there would be, consulting costs with every project and every drill, every borehole.
Do you think every one of the projects has this similar type of cost structure to it?
It's something similar, I believe, yes.
So a few areas back, this board also approved a change to a change to the cost structure in your leasing, where you were not going to pay an additional shut-in fee to all the parties involved in that unit. You familiar with that when we did that? At that time, I believe Q-Rock stated that few thousands of dollars would make these projects entirely uneconomic. You would not be able to do it if you had to pay the shut-in fees. Now, can you explain to me today how we can add $1.5 million to it, and any of these projects would be economic?
Unable to.
Other questions from the board? I make the motion that we deny the request to change the ad, and do I have a second?
I'll second.
Whole board is going to.
Mr. Owens,
Yes.
Mr. Harris,
Yes.
Mr. Jansen,
Yes.
Mr. Mullins,
Yes.
Mrs. Gibson,
Yes.
and Mr. Cochran.
Along with this, I just want to be sure that, Mr. Street, to go back to his original AFE that he has been provided part of this application. And his timeframe is extended for at least 30 days from today's period. He can make his election if he chooses to elect to be a participating officer. Operating with well, since we've extended this timeframe, I don't want to go back at the time. So we have to ask the risk for the department of the
So Jason, that's this question. Is this order been entered, Ms. Gilman?
No, sir.
Sir, I have not yet received the final order, so no one has sent me the order that with the pooling election. I'm still awaiting that.
Okay. It's not been entered yet. This file for this.
Let's make sure we have the timeframe, additional time.
That'll be noted in this order.
So I'm sorry, when's the deadline? I'm getting ready to go on a long vacation. What's the deadline now?
It's 30 days from the date of receipt of the order that you have an election to be made in writing.
Okay.
And we anticipate that supplemental order be submitted what time from?
Should be ready to go.
We should.
So I'm
We-
leaving on not to trouble you with my problems, but I'm leaving on Tuesday for a 33-day vacation out of the country. What do I do?
The original order has not been entered. I'm holding on to that. I've not processed it.
Okay.
It still has to be recorded.
Okay.
Then they will submit their supplemental order.
Okay.
He'll have time.
Can I communicate by email?
Yes, sir.
Thank you.
And I can send you a copy by email.
Okay, and thank you for your decision. I have to say to the board, if I may just conclude, I have great concerns about working with Key Rock now, given this experience I have had, and whether they will fairly allocate costs to me as a working interest owner. So that's just my concern.
Mr. Stuckey, just for your information, I believe that the board can require that any and all counting of costs can be reviewed by the board at your request. So if
Okay.
you do have concerns, you can take that up with the staff, and those can come to the board also.
Okay, thank you very much. It's helpful.
District Interest Operated LLC for repooling of the North Colvin gas field using BC -504 365. Document number VGOD 23-0418-0261-01. All parties who wish to speak this matter, please come forward.
It's Larry Reeves, Intervest Operating LLC.
Senator, do you
Swear in.
swear in the witnesses?
Mr. Reeves, do you swear and affirm that your testimony is the truth, the whole truth, and nothing but the truth?
Thank you, Mr. Chairman. Mr. Reeves, please state your name, where you may report your job description.
Larry Reeves, I'm employed by Interest Operating Mandate.
And this involves a retooling of the machine, is that correct? And, this unit contains 58.8 acres, is that also correct?
Yes,
And presently, Intervest has a substantial portion of this unit under lease and or, as an owner fee, is that correct?
that is correct.
We have just one person listed on the exhibit E3, is that correct?
Yes.
And she's unknown, and, so we're not going to dismiss her today, is that correct? So since mailing was not possible, how was notice of this hearing effective?
We notified, Bluefield Daily Telegraph. August 1st.
We provided proof of publication to the board, is that right?
Yes.
Is there an escrow requirement for this unit?
No, it's good.
And obviously, the Intervest is authorized to that this is in the common, is that right? So there's a bond on file with the department.
There is.
And if you were able to locate this party listed on it, the free or errors, what would be the terms that you would offer for these?
$5 an acre a year for a point paid up lease.
This is fair and reasonable compensation, is that correct? What percentage of the unit does Intervest have under lease present?
94.2957.429%.
And what percentage of the gas savings you seeking for?
5.70428571%.
You're asking for more people that have this, is that right?
We are.
And that Intervest be named the operators of this unit?
Yes.
And if you were able to reach an agreement with the parties listed on exhibit B3, and an election was made under order entered by the board, what address would be used for the elections?
Intervest Operating LLC, 408 West Main Street, Akron, Virginia. 210, each of them, Kevin Miller, Vice President.
And that would be the communication for all correspondence regarding the scene, is that right? And are you also familiar with Stephen as well?
Yes, well, that's 3,200 feet,
And what about the estimated reserves for this?
850 MMC.
And you participated in the preparation of the AFP that was submitted, is that correct? And this is revised from the original submitted in April 2003, is that right? And what's the estimated gravel cost for this well?
Dry hole is 311,717.
And the estimated fuel cost?
They did this 800,887.
And in your opinion, if the board grants our application today, with that waste for conservation and for rights?
Yes.
That's all I think.
Questions from the board? Just a couple of things to clarify here. This application is originally approved a couple of years ago.
Yes.
Did it expire? Or is this application usually expired? And we're approving today unknowns.
And unknown, yes.
And so you have not made any progress on identifying these unknowns in the past 2 years.
No, several different have the same party that we've done research on. It's lost back in the early 1990s. Making progress on.
One of the questions I think this is handled typically during the permitting process, but I think this is before the board is given record on. Is the original well in this unit is outside the unit. You know the reason for being outside the unit, the only been there in this unit? Last 3,000. Interesting to me.
We thought, I'm assuming it may have been for terrain in this area because I do know the terrain. I've been to this location myself, and there is a big ravine valley that runs through here with a creek and state road that runs in that area. I do know with the other well, it's on the other hillside. You can say.
I'm sure that, permit is still active, or did the permit also expire and if they need permit
On the other well,
on this well on this unit?
the permit had expired on this one, or they are renewing the permit.
Permits have been used, that will be addressed at the end of the process.
Yes.
It's just one other clarification. I've had some discussions with the staff on this too. We're calling this a repooling. In the original order that expires, it goes away. We're not just pooling it in on I think a repooling, I consider repooling when we're making changes to a unit. Are we repooling or we're doing it all over? It's like it never happened at this point.
Well, we had asked Steve more about, because I had permission for pooling, but whatever the board's pleasure.
I think we're gonna have some discussions with the staff on this and maybe some guidance.
Just let us know.
On how this needs to be done. We've seen it done both ways, and I didn't know what your position was on else.
I'll just submit it twice, how's that?
I can change that if you all want to change
I
it.
think we just wait until you have guidance on how we need to be doing that. I think it's just this issue.
Let's also address the dash one. Call it pooling or whatever. Other senior discussions.
Any other questions? The board operates under a motion. Do I have a motion?
Motion to approve.
I'll second. Let's go with Paul the board, please.
Mr. Owens,
Yes.
Mr. Harris,
Yes.
Mr. Jansen,
Yes.
Mr. Mullins,
Yes.
Mrs. Gibson,
Yes.
and Mr. Cochran.
Yes. Thank you.
Thank you.
Item number 5 on the docket is the petition for diversified deduction will transfer of the right to operate all units listed in the petition that were established by the board or the Summit Appalachian Operating LLC. Diversified deduction, operating TGOB 25-089-329. All parties who wish to speak to this matter, please come forward.
Terry Barber, Street One, that's for the street. And then we'll have to pay flat for it.
And Mark Swartz as well.
Mr. Cole, will he stay or did he leave? Yes. Yeah. We'll swear in what witnesses we have here this time.
Mr. Blackburn, do you swear and affirm your testimony is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Is anyone else going to be speaking?
Mark Swartz.
Tom Pruitt with Buchanan Energy Company. Our witness is Jason Davis.
Jason, do you swear and affirm your testimony is the truth, the whole truth, and nothing but the truth?
I do.
Mr. Blackburn, can you state the name of the record
Craig Blackburn,
and who you work for?
Diversified Energy Company,
What's your job title?
Director of Land,
What are your job duties?
overseeing land operations in the southern division of Diversified, which includes Virginia. That would involve leases, rights of ways, contracts, agreements, and negotiations with landowners, third party operators.
How long have you worked with Diversified?
Since 2015.
And what companies have you worked for before Diversified?
EQT, Clean Gas, Chesapeake, LG, KU, and Core,
How long have you been with the gas and oil industry?
25 years.
What about before the gas and oil industry?
I attended college and high school. I was in the U.S. Army and National Guard for 13 years. I was a police officer.
Is Diversified Production LLC authorized to conduct business in Virginia?
Yes,
Does it have a blanket bond?
yes,
Are you in line with the application that we have submitted with the board?
yes,
And we are asking that 44 unit transferred over to Diversified Production LLC. Correct?
that's correct.
And Summit Appalachia Operating Company, they have authorized this transfer,
Yes,
and you've submitted a written approval with the board, correct?
yes,
And are you aware if there was any notice given at this hearing today?
yes.
And what was that through?
Bluefield Daily Telegraph.
And could you tell us, with this change of operating, change of unit operator, would any owner's interest be affected? in your opinion?
No,
Okay, would they be paid exactly the same?
yes, just a different operator.
Okay. And have you been involved in any of these types of transfers of units before?
I have.
And what was required, was it a publication or mainly required in those?
No, not for the previous two that I was involved.
And can inform you that that was not a requirement.
That was just at the direction of the board at that time.
Any questions to the board?
I won't be speaking to this, but the following. Should have objections.
You're not speaking to kind of five.
Right.
Mr. Swart, did you want to make a comment? Line number
Yes.
5?
I would like to make a comment. First, I have not seen what was published in the Bluefield Daily Telegraph, or at least I'm not sure I've seen a complete publication, but I don't believe the publication in the Bluefield Daily Telegraph identified the owners and claimants in all of the units that they're seeking to change the operator with regard to by name. So that I don't think that my observation would be that the publication in the paper, if you don't tell people by name that they could be affected, I question how effective that would be. There is a specific rule, a board rule in the Virginia Administrative Code that has been in place since a long time. Okay. And it's for VAC 25-160-40, talks about notice of hearings. F is the last piece of that. And it says an applicant filing a petition to modify a forced pooling hearing order established under, and 1622 would be a CBM unit, to change the unit operator based on a change in the corporate name, which is not happening here. A change in the corporate structure of the unit operator, it's not happening here. Or a transfer of the unit operator's interest in any single subsidiary, parent, or successor by merger or consolidation is not required to provide notice. So there are 3 exceptions to the notice requirement when you're changing operator, and essentially they all are, if you're doing a transfer to a parent or a sub or an affiliate, and you're dealing basically with the same people and the same financial structure, there's no requirement that you give notice. And then the last sentence says, other applicants for a hearing to modify a forced pooling order shall provide notice in accordance with 45-2-16-18 of the Code of Virginia to each respondent named in the order to be modified whose interests may be affected by the proposed modification. So this application was not mailed to the probably hundreds of people that would be affected by this change. I submitted to the board a press release from Diversified that identified this as an acquisition. Diversified, quote, announces the close of its previously announced acquisition of operated natural gas properties and related midstream pipeline infrastructure. And it identifies these assets as having been transferred from Summit to them. So I would suggest that until a notice, for complying with the board's rule and complying with section 45.21618 of the code is provided, we shouldn't have a hearing. Lost our picture of the board, I think.
Still recording.
We have you
There we
back now.
go.
Is everybody back on the line there?
We're back.
Where did we lose you? Where did we lose you guys, Mr. Schwartz? Do you know? Their discussion?
Did
As
you,
soon as
did,
Mr. Swartz concluded his comment, we lost you.
okay, good.
Okay.
So I get a redo? Okay. What I said previously is, Mr. Schwartz, I appreciate your position. I have to disagree with the interpretation of the regulations and, I'm thrown off a little bit. Okay, so Mr. Schwartz has brought up 4B AC 160-40, but the change of unit operators is actually under 4B AC 25-160-120. And in there, the only notices required is through the board's published decision. And that's because there are two different sections. Section A refers to simultaneous mailing, which is what Mr. Schwartz is referring to, but that's only in circumstance of a pooling application or bill exception tool. What Mr. Schwartz is referring to for BAC 25-160F does speak to modifying pooling orders, and it has specific language in it that talks about notices not required in certain circumstances. And this is for, as Mr. Schwartz has said, change in the corporate structure or corporate name. And he's insisting that what we have done here, the purchase of the assets, is not the same. But if you go down to this last sentence where it says other applicants who are going to modify, of course, the pooling order shall provide notice in accordance with 45.2-1618 to each respondent name in the order to be modified whose interest may be affected. And we spoke with Mr. Blackburn earlier today. He testified there is no owner who has interest that is going to be affected by a simple ownership change. And that's all that we have. And here in this regulation, it's similar to a change in a corporate structure. And just because it's not listed here does not mean that notice is required by mailing and publication, as Mr. Schwartz has said here. In fact, this has not been the behavior of the board before. Mr. Blackburn has testified to that. And also, if you really think about what you would be requiring of every company, we have 44 units. We pulled 2. I did over 50 certified mailings. You're looking at closer to 1,000 mailings to notify everyone that the corporate structure has changed and now there's a new ownership. And I just don't think that is necessary under the regulations.
Thank you.
There was no change of corporate structure here. Diversified's own press release says they bought assets, okay, from an unrelated party. The section I'm relying on is entitled Notice of Hearings. The last bit of it that I've been talking about is specific. It says an applicant filing to modify an order to change the unit operator has to do a mailing if it's not a change in corporate structure. And that's, they're required to mail. And the fact that it's expensive, I mean, we have done pooling applications where we've sent out 500, 600 certified pieces of mail for one application. People are entitled to know if they're the company that's going to be managing the calculation of their royalty, their costs, the deductions, and managing this property is being changed. I mean, to say that it's irrelevant, it's not the case. We're changing the company, or proposing to change the company that's going to manage these units and the money.
Thank you, Mr. Schwartz. Ms. Cooper or Mr. Lansing, do we have any guidance from our legal side here today?
Could you restate the question, Mr. Chairman? I couldn't hear you.
Yeah, I was just thinking if we had any guidance from our legal counsel here today on this matter and how we should proceed. Your interpretations.
Sure.
Jesse, was this a matter that we want to
This-
discuss in closed session first?
No, this is a new, separate, separate matter. I do think it is up for the board to interpret the language. And whether they think that this, falls under the scenario where it is outside of the exceptions of, 16040 F, which is the change of the corporate name of the unit operator, change of corporate structure or transfer, or as counsel for Diversified stated, whether the rights are not so affected by ownership as to require a change. I do think that is just a factual question for the board.
Questions for the board or questions?
I would like to ask, actually, who was notified?
The only notification we put was through the newspaper, so it was, in the building.
But it was not individual to the, organization.
I'm sorry, I'm not sure I heard that. Is there a contention that somebody was notified in person or by mail?
I think Ms. Gibson was just clarifying that there was no mail into any individual, so it's just in the paper.
Okay, thank you.
Other questions or discussions? So I think I would ask if it's going to make this and say, rule whether we keep going to closed session or push this to be able to have discussion between the board before we make this decision. You want to go into closed session? You have some discussion concerns, I guess, also. Myself personally, yes.
Yes. Yeah, I tend to agree also, but I do have a question. We've done this in the past. I can't see you specifics, but in that case did you have notice them to, folks that were being pool or part of the project?
I'll have to read on the staff for past. It sounds like from what I've heard from testimony the other day in the past, that it's mostly been who do a notice in the newspaper. But, that cases of everything.
Yes, sir.
More recent ones, there may be some that go back further. Where they may have, and this all hinges on the fact of whether this is a corporate change, name change, or if it's an asset.
Shoot. If I could add to that, it's been a long time, but my current client, has gone through a ton of, corporate changes over the years, and I have from time to time changed operator for what I'll call now CNX related companies. I mean, you may recall that Oxy USA was purchased, the Can Production was purchased, the companies and so they were related companies and affiliates, and they weren't buying and selling individual wells or pipelines. And in those instances, we came under the exception. And I don't really have a recollection if other people have filed in the past under the exception or not. But I know I have done that on behalf of related companies and my clients.
Open the source.
So you're saying the notification that you got, no way that is individual, you would not make any change other than the corporate manufacturer.
Yeah, it was the language that I did, basically when the thing is one is that the ownership has changed. Yeah, that is,
It's everything else with them plus that. So the
Right, there's no need to notify everyone because it was simply a change of ownership. Nothing has been changed that would affect it. And the limitation of the individual. Facebook, Facebook, on the face. Nice chatting face. It was the notice of hearing that was in the affidavit, that's what it was, is that Diversified was applying to the next promise. That's what. No, this time, this is four story units, and like I said, I needed 2 units just recently, and it was 50 to 60 people. So we're talking and I'm over, it could be over about, it's really depends on how people. So it could be hundreds, it could be up to 1,000, so I'm not sure we have. That'd be sure.
Any other questions or discussion? And a motion, how we'll proceed here.
I'll make a motion that we table this until we go into the closed session, further discussion. It'll count.
I don't want to take the table, that's, it's off,
I'll table, so I can get to the closed session. Make a motion to go into closed session to discuss this.
I'll second that. Okay. For the board for the closed session.
Mr. Owens,
Yes.
Mr. Harris,
Yes.
Mr. Jansen,
Yes.
Mr. Mullins,
Yes.
Mrs. Gibson,
Yes.
and Mr. Cochran.
Yes. Okay, the procedure, as I understand it, we're going to exit the room, we'll put the recorder on hold at this point in time. We have another room that we have available to go to. Is that correct?
Yes, sir.
Ms. Cooper, Ms. Lansing, Mr. Lansing, you're available, that we can call you on the phone. Discuss this further. So we'll adjourn until we have this discussion. We can take too long. We're
going next door, you
already stay here. Medical record here. You need to correct a procedural matter here before you go into closed sessions. Attorneys there. So there's going to be the board on its own motion will enter closed session as part of the Virginia Gas and Oil Board meeting on August 19th, 2025. Virginia Oil and Gas Board hereby resolved to discuss the following subject matter in closed session. This meeting will be in consultation on a memo circulated to the board by the Virginia Attorney General's office, as well as legal matters involving items 5 through 12.
Mr. Chair, I'm sorry to interrupt. I think we need to revise the resolution to reflect this particular matter that Mr. Schwartz has raised. Is that right?
Yes, Eric, that is item number 5.
That was item number 5. That's what I was trying to address that. I always in one closed session.
Okay.
This subject matter is exempted from the open meeting requirements in the following positions of the Virginia Freedom of Information Act. Consultation with the legal counsel employed and retained by public law in regards to specific legal matters requiring the provision of legal advice by such counsel. Pursuant to the Virginia Code 2.2-3711. That's the motion of the board on its own motion. Do I have a second?
Second.
The motion is second. Now we'll. Let us prepare. Part of the mayor to do here and say that. Is he coming? No.
I don't think so.
He's gonna skip the vote. We're gonna carry the vote. For that to be that. So we'll vote what board members have here.
Mr. Owens?
Yes.
Mr. Jensen?
Yes.
Mr. Mullins?
Yes.
Mrs. Gibson?
Yes.
And Mr. Cochran?
Yes. We have 5 votes yes. Mr. Harris will be counted as an extension since he is not taking that. So now we're going to go into closed session.
But Mr. Chair, I'm sorry to interrupt. I'm having a hard time hearing, just because of the sound dynamics and me dialing in remotely. We are
What's your question?
going into close. Are we going into closed session to discuss the matter that Mr. Swartz has raised?
Yes, we're going to discuss those items as well as items that may be affected by docket items 6 through 12. Plus
Okay,
item number
and-
5, which we're currently on. We're going to do it all in one closed session.
Okay, and has the resolution been revised to add the additional matters that Mr. Swartz has raised to
Yes, it
include
has.
that in the resolution?
Yes, it has.
Okay, thank you. I appreciate it. I couldn't hear because of the sound dynamics. It sounds like it's all captured. As long as the resolution reflects everything that we're going to discuss, then we're in good shape.
Yes.
Okay. Thanks,
Okay,
Mr. Chair.
no questions. Okay. I've got this resolution notice, Sarah will take care of that. We'll go back to closed session. Okay, everyone, we're back on the record. Ms. Gilmer will do the exit polls with slow please.
To the best of your knowledge, did the board restrict its hearing, discussion, and consideration in closed session to only public business matters lawfully exempted from open meeting requirements under this chapter, and only such public business matters as were identified in the motion by which the closed meeting was convened? Mr. Owens?
Yes.
Mr. Harris?
Yes.
Mr. Jansen?
Yes.
Mr. Mullins? Mrs. Gibson?
Yes.
And Mr. Cochran?
I need a motion for the board to end the closed session. So moved. I have a second. Second. Hold the board. Close the meeting.
Mr. Owens?
Yes.
Mr. Harris?
Yes.
Mr. Jansen?
Yes.
Mr. Mullins?
Yes.
Mrs. Gibson? And Mr. Cochran?
Yes. We're back. Track here. You're back to item number 5. This diversified progression transfer operator comments. This presentation in the status of meeting in Senate Appalachia operating LLC. Board has a discussion and has recommendation from the lady's office with the notice is insufficient. So the board will need to make a motion to continue this item until such time that the applicant can achieve that required notice. And we'll hear some input from the parties there, and then they could get that notice done. We'll talk to that each talk about that each month and one person.
Would we like to hear that? Well, the question before the board is which the board entertained and a proposed temporary order designating Diversified as a unit operator, so that a unit operator has been designated, and then allows time for us to notify those parties.
What would be the purpose of the temporary order?
Well, I mean, Diversified is already operating as unit operator. All this is really the last step. So that would be to protect those who, I mean, there are a lot of ways you have a unit operator. There's a violation, unit operator that need to be contacted. So that would put Diversified in the position as unit operator, operating that unit. And then we will move forward, going ahead to notify those as requested.
So will those violations be related to permits? The permits have already been transferred, to my understanding. That's already in place. It's just kind of the formality of transferring these units or these cooling orders to be right there.
That's correct.
So this Diversified's contract with Summit Appalachia allow you to conduct business for a certain amount of time till all these things are rectified? Is this temporary?
We're signing bill of sale. We purchased the West.
Right. So, but until this is done, does this affect your business? How does this affect your business?
If we're not the operator of record, how should we continue operating wells and paying the operators?
That was my question on your contract with Stone Appalachia. It's usually most asset sales have a time frame, a period of time where that operator transition takes place. Is that not the case that you have in place here?
I don't know if there's any particulars to the actual time frame. I guess that probably wouldn't anticipate any of the regulatory requirements of certain states because we bought assets in Virginia, Tennessee, Alabama, and Florida.
Mr. Chairman, if I could weigh in for a moment, I think the well permits were transferred in February and
That's right.
presumably have been operating just fine. I don't think we need to do anything at this point other than instruct them to give the notice that they're required to give, and we'll have a hearing on the merits of the motion.
Mr. Chairman, I've been told that the time period has already expired.
So
I'm sorry, I didn't hear that.
I stated that I've been informed that the time period has already expired.
What time period?
Transition service.
In the transfer. Yes.
he may have missed the question. So have you, as Diversified been reporting payment from all its oil and gas owners, or they've been going ahead and conducting business as usual?
Yes.
Okay. So I'm not sure that a temporary order is necessary for anything that you need to do for your business. Unless you think it's going to take you months and months and months to
Well,
get this notice.
One of my questions would be, if when the pooling orders were established in 2010 or whenever, if the owners, have they changed since then? I mean, we can only go on information that some provided us with ownership decks. So if that's not current, we could use that. But would title need to be ran on ownership going forward by all the owners?
yeah, this is what, our concern is that we're going to have to go back to these 2009, 2010, whatever pulling orders. We're going to have to get the owners, their addresses, and then we're going to have to move forward and see if any of them have passed away, who are their heirs. And so that is going to be a bit time consuming and it's going to delay us. And if there is no temporary order in place, then that's something that we're going to try to hustle to do. But I don't know how long it's going to take us to do.
I mean, are they telling us that they have made no changes in the people they pay royalty to in the last 15 years? I mean, your records on royalty and division of interest and your predecessor's records, Summit, they ought to be up to date. I don't know what you're talking about.
I can't give a clear answer of how long it's going to take. There's going to be quite a few periods, and I don't know that I have that in front of me. So if it's the board's position that we can't do temporary order, then we need to try to get it done within the, as soon as we can, get this back on the dock.
So the board's motion then. Mr. Treasurer.
To the question just asked. The notice that Pocahontas Gas is referring to statutory notice in 45.2, 1618. And it does only apply to 3 scenarios. This would be an expansion, but even if we do the expansion says notice a commercial delivery service. Return receipt requested to each gas or oil owner, coal owner, and mineral owner. So it's more expansive than just it would be on gas royalty owners list, a list. But So if you're talking about, 44, did you say?
44 units.
44 units and 20 to 40, there's the 40 to 50 per unit that you estimated, does that include all of those?
I don't know how many errors are, some are a lot more errors than others. This is just based on what we did recently. So I can't say that that's an accurate number, but I'm just saying the two people have some.
To get that information, right, I think the title where. Now that could, Charity does have to sleep a little bit after she gets that. You're talking, that's an overwhelming task right there. That could be months and months on all of.
Yeah, I understand. And I understand that Mr. Force's position also that in theory, that data should all be up to date in your records. As you had landowners come forward over the years, whether they did or not, sometimes we have this happen.
Exactly. It's only as they come forward that we make the change.
So, I guess it's the board's pleasure to include within this motion to continue this definitely and to have a temporary operatorship assigned. I'm still not clear as to what the reasons you may need that for are, but you can certainly make a motion. That's the board's pleasure.
I mean, we should opt it. What do you think?
She's asking if there is if we can have a hard end date for getting this data in. Instead of having it open in.
Well, you know, if I were a company trying to get people to the pool, I mean, I can't imagine I would notify 30 people, 30 days to notify all of the potential owners. I'm not sure what, and Appalachia, or Summit Appalachia, what's their role? This is for board members. Would they have any obligation to certify that everything is up to date? And who checks that?
Summit's the operator. They still are on the hook to the board to make sure that people are receiving their royalty. And if people have passed away or made transfers, that the royalty information is up to date. That's why there's a transfer. You can't just walk away from your job as operator. Summit's the operator. And you've got the well permits, but Summit is obligated to do this job. And they're not here today.
Anything else, Mr. Schwartz?
No, I'm sorry. I'm sorry. Yeah.
So is Summit the one that should certify to these folks that everything is up to date? I guess I'm in that one.
Yeah, I'm not sure what your due diligence was when you acquired the property and what your requirements were. If some engineering to get transition agreement, again, that's beyond the scope of this board. And again, I'm not sure that those contracts that you all had in place, which are now expired, since this has been 6 months ago, this would have been held 1 month after your acquisition. Maybe you would been able to rectify this by now. We're not in that position for that. So at this point in time, all we can do is go by the fact that the notice is insufficient and it needs to be rectified. And all we're asking is for you to give us time frame, or we're going to dictate the time frame that needs to be done within with your input. But or if the board so desirable to issue the temporary ordinance, you feel like you need that to conduct your day-to-day business.
Maybe to me more than him, but I think you're looking at him, so.
I
understand the Poland orders that were established in 2010 are going to differentiate from today's decks, ownership decks that those are being paid. That's going to be different. It's not going to match up.
I understand. So, and I don't have a clue how long that's going to take. I don't know what all's involved.
Without diving in and looking at it, I can tell you.
I would suggest this, board's approval, that is set an initial 90-day period. Then,
Jared, if you need more time, you can come back as that's the board.
In the meantime, temporary.
Again, that's the board's decision if we need to have that as part of the worksheet. And we feel that's necessary. I need discussion from the applicant if that's necessary.
I'm crack while he's thinking, let me talk. Maybe he'll figure out what's wrong. From our standpoint, we can just, from a day-to-day operational, we're producing gas. We've been paying the royalties. But on your records right now, Summit is including the operation. They're not for the board, they're not on the property, they may not have insurance. As far as they know, their assets, they sold all this to us. But unless we want to drag them back in for all this stuff, we need to sever that. Put us as the unit operator as we're, I don't want to suggest we're not entitled to be that. It's just procedural.
Yeah.
So put us in place, that way you have you get a notice about violation, or if Mr. Boyd wants to contact the operator, he calls us, at Summit, we can continue to pay under the order. There's no prejudice that way to any interest holders or Summit or to us. And somebody's got to. So it should be us right now. And then in 90 days, if there's objection, and interest holders, we could take that up at December meeting.
Well, they've been operating this for 6 months without anything. But why can't they operate it for another month or two while they give notice?
Because they transferred. Means transfer permits.
Yes, I don't know the answer to that question. 90 days for I'm okay with the start of 9 days.
Sharon doesn't kill me, I'm gonna go ahead and say, we think so. We need more time, we'll.
Be a starting point.
Yes, ma'am. We'll be diligent and do the best. We'll notify the board as soon as we can. We have a couple of outside firms we can contract with to help us expedite.
Or staff, do we have the authority to issue or ask that a temporary, unit operator, please staff for diversify? In other words, I'm not sure what's involved in the.
I would assume so. I would assume we can put that in our order. Have a temporary order if you direct us to.
Not sure what that means, a temporary order, but I would think that we need somebody that we contact in case there is an issue.
Well, all the permits have been transferred.
Yeah.
Right.
Does you already have a contact person?
Yes.
So really almost like he is.
These are only for board items. Just board items.
It's just thinking out loud here, if a oil and gas owner came forward with a problem being paid under the existing order, they would need to talk to Summit Appalachian stuff. After they contacted you, who would you direct?
I would direct them to diversify,
But technically, until it's transferred, Summit Appalachian would be the responsible party payments weren't being made on.
I guess, yeah.
Yeah.
Well, that's something that Craig brought up to us, the two people who walked in today, contacted Summit. And it was over stuff that we sent them, so they believe the Summit friendly operating, and they contacted Summit. So this, there are reasons for us to be established as the operator.
So so I'm looking at, I think you as council, we're now made our operator of those wells that they receive royalties.
And you should,
Absolutely.
Mr. Chairman, we're oil and gas representative for Canada Energy and called representatives under this, and it just doesn't seem to be good practice to leave this hall. And they brought it to you and said, look, we need to patch this problem. Right. And you didn't like the patch they presented, and you give them another alternative, but the hole remains. And as lessee or lessor read, we'd like to see an operator mention.
Yeah, so the board and staff, what's the problem with designating them as, giving a temporary designation?
I think what's lacking in the procedure is no time frame that requires these board orders to be transferred timely. That's probably what's best today. There's no requirement that you have to be within 30 days, 90 days to settle. Or take as long as you want. I think we probably had something that's gone on for years in the past before they got transferred. But those companies were still under an obligation to their contracts with the private operator that allowed them to continue to take business. Now, I'm not.
Diversified, we've been through the same scenario before here in Virginia. When Diversified bought the EQT assets in 2018, when Diversified bought the Nidus Carbon assets was the Innovex properties in 2020. We've done the same thing with no hiccups whatsoever.
Well, okay.
And we had no issues. We changed ownership of units as we transferred permits. We continued to pay the royalty owners without any hiccups. Without being the operator of the units, do we pull back and not pay? We put everybody's money in escrow. To me, if we're looking out for the mineral owners in Virginia, we want that transaction to be as smoothly as possible.
I agree.
We're to hear the public question. This one?
No.
About a mineral question.
Well, it's the same problem. The people, if there was going to be a request for a temporary transfer, it should have been an application. Nobody really had notice of what was going to happen today. Pocahontas has 19 units on your list that you want to transfer, and you didn't send them one letter.
We were just following orders as we had done in the past, as presented to us by the board. We had no reason to come here to expect anything should be different.
I understand. And that is one of the reasons why we involved the Attorney General's office, the interpretation of what needed to happen. That was their recommendation to us. So the notice probably in the past was probably insufficient also. We're not sure how that can be rectified. But we do know how to rectify it at this point in time. Again, I'm looking for the board to provide me with a motion to continue this item for 90 days and or including a temporary operatorship if that's the board's position. Board's going to go down that route. That helps the operator.
I'm in favor of a temporary, of course, we're not making motion, but the temporary operation for Diversified while we're waiting for this other issue that they attended. So therefore, I'll just make that a motion. And
we have a motion. Does everyone understand the motion?
Motion is that they be given a temporary operating permit for these gas wells that we're talking about
For the unit.
For the unit, I'm sorry, for the unit, yeah. And, that temporary, of course, is contingent upon our getting the, indication that proper notice has been sent. Now, what happens if we get tons of objections from that? I guess that's going to be treated separately. But I do feel that we shouldn't leave a vacancy in terms of the, who's operating and who's responsible in case there are some questions. So that would be my motion, that we issue that, and then in the meantime, wait for the other items to get taken care of.
In your motion, we included an additional 90-day time frame.
90, if that's agreeable, to the 90 day, yes.
If that time frame is not sufficient to make it back.
In the meantime, we do have an operator who's in place.
We have a motion. Do we have a second?
I'll second.
The whole
Mr. Owens,
Yes.
Mr. Harris,
Yes.
Mr. Jansen,
yes.
Mr. Mullins,
Yes.
Mrs. Gibson,
Yes.
and Mr. Cochran.
Yes. You have that. We will.
So put that on November.
Question. And this may be a question for your council. But I mentioned earlier that under that statute, we have to notify like clean old coal interest owners. And that may or may not be necessary. We'll do what the board directs us to. But the notice statute says we have to notify any interest holders whose interest may be affected by the transfer. Arguably, the coal owner interest may be affected by a transfer. So do you want us, do we need to notify all the coal owners and service owners? Or do you just want us to notify everybody and just forget trying to horse it out? That's a, requires some change.
Would that be easier for you? You don't have to go through the separating.
Technically, you should probably notice that everybody who's on all these applications.
Yeah.
Everyone who's on the beat here, any updates that you come across.
The B3 and their successors as it's changed is exactly what I think.
You're not messing changing us too.
And we know that's a lot of flailing and steps. But as I said earlier, cost of doing business sometimes, that's what it comes.
Thank you. Yes. Well, thank you.
So November is the date I should put on.
Thank
that.
you.
November 2025. That's 90 days, isn't it? Okay, September, October, yeah.
Next item on the docket, it's number 6, the petition from Pocahontas Gas LLC to be pooling with COVID methane gas field number 2. It is D39, docket number VGOD 06-0221-1577-02. This item is continued from July 25 hearing. Ask all parties to come forward. We would like to address this issue.
Mr. Chairman, before you jump into those, items 6 through 12 have a property owner that I have a business conflict with. So I will abstain from conversation on this.
Please.
Mark Schwartz and Kelly Berry, Mr. Chairman.
Mrs. Berry, do you swear and affirm that your testimony is the truth, the whole truth, and nothing but the truth?
I do.
Chairman, point of order, it's. Can you get notice of what we're going to do? This is a hearing.
This is a regular hearing under this docket being heard today. It is my understanding that these were continued from the June hearing to July. Well, from July, they were continued due to 2 objections. One had to do with improper notice, and the second one had to do with certification with track agreements. It's my understanding that those 2 objections have been rectified. The applicant at this point in time, I don't know if there are further objections that are going to be brought forth during this hearing.
Maybe I can speak to that. I don't know how much the board knows, but since the last board meeting, we received notice from the division. All of these cases would be put on the track. So we got notice from the division that you're no longer going to have a formal hearing on August 19th. Instead, it's to the informal conference track. So we convened at the request of the division, we convened a pre-conference telephone call, which lasted 3 hours. There were at least 10 people on the call from all the parties. And we were, it was explained to us at that time that we would proceed on the informal fact finding conference track unless all of the parties waited.
Okay, so let me just hold it right here. There have been some changes in some of the procedures that have been outlined as part of that pre-conference hearing. It's part of what we're in closed session for earlier. So, first, it was my understanding, and again, that the pre-conference hearing was held was primarily for the applications under items 9 through 12, which had competing applications for the same unit. 6 through 8 did not have any competing applications for those units. So are we talking about having the same issues with those units also today, or are there going to be more objections that you intend to bring forth with that? So I guess first, let me back up just a second. Maybe the appropriate thing to do here is to have Mr. Schwartz assert his position on this docket item, and then you can respond to that. Since both parties, we will go from there.
Okay, my position is, I'm ready to have a hearing on whether or not the board should grant our application regarding G39, whether or not we will be allowed to repool that. We've already pooled it under Oakwood 1, and whether or not we'll be allowed to repool that as an Oakwood 2 unit or under Oakwood 2, so that we'll be allowed to produce gob gas. We noticed it for June. It's continued. We're ready to go, and the board, our view is we noticed it for a formal hearing in front of the board in June. The statutes provide that the board holds formal hearings, and we're ready to go.
The first indication we got from as to what the informal conference was to to 5 document item numbers. Remember, this was an email from July 24. Well, I'll just read the last 6. The first one was 157702. The second one was I'll be tagging on this one. 06174308, 06174309, 07154311, and 07154312. So that was a July 24th email from on behalf of Division Director Rifa, saying that we need to have a telephone conference to establish if the involved parties wish to keep this an informal proceeding under 419. So that's what led to the telephone conference, which was a 3-hour conference. First order of business during the telephone conference was to ascertain whether all of the parties would waive the right to have that informal conference. Oconus gas indicated they want to waive that. The other 3 parties on the phone call declined to waive. So the 3 out of 4 says we don't want to waive. We want to have the informal conference. The remainder of that telephone call was specifically and only designed to get information and share information and arrange for procedures under the informal conference statute, which is just for ease of reference, is 4019. So throughout that 3-hour call, everything was, you're going to have an informal conference. We need to share information. Parties shared information. We all got to talk about what the issues would be. what the facts would be. And that was specifically so that the divisions could answer and provide information under the informal conference statute. At the conclusion of that 3-hour call, we were told you're not going to have a formal hearing. What you need to do is show up at the meeting today, August 19th. And at that point, we may have an informal conference, but we probably won't. Probably need a designated hearing officer. That's the notice we got. That's the notice we got on July 30th. That's the notice we got for the next few days. That's the notice we were all sitting on until 7 days ago. 7 days ago, we get this email that now indicates not that we're going to have a formal conference today, but that the board might vote to have a formal conference, or it might vote to have an informal conference. There's no notice telling us you need to show up on the 19th and have a formal hearing. That's not what we were told, and that's not even what the August 8th email said. But in any event, we didn't get any indication, not even a hint, until like 8 days ago, that this might be a formal hearing. Now, the board just had a long closed session to discuss some complex issues in the case, which we appreciate. They are complex, they're novel, involve a change of some of the procedures the board has followed. That involve interpretation of old orders, questions about whether there'll be multiple operators in the unit. Whether F-37 is 1 unit or 2 units. I mean, the list goes on. And that's not the type of hearing that we can do in 7 or 8 days notice. Even an uncontested hearing where no one's going to come forward and object, you get 30 days. So we got 8. And now all of a sudden, hey guys, let's have a formal hearing. That's a problem. We have, this is a big issue for our clients. We have at least 8 or 10 of them here today. And if we're going to do a formal hearing on this, and I would submit to you that we can't by statute, but it shouldn't be today because we don't have adequate notice. Moreover, under the formal hearing statute, which is 4020, 4019, 4020, we're entitled to some pre-hearing notices that we did not receive. Because of all of those things, your counsel, the Attorney General's office, told us in the August 8th email, it is highly likely that substantive hearings on these matters will need to occur after the August 19th hearing. Due to notice requirements. That's from your attorney. We agree with that. You got notice requirements that haven't been choose. So we object to that, to a formal hearing on all of those grounds because it's not fair. But what I would submit to you that what needs to happen by statute is you have to get us a chance. That's what the statute says. Sorry, the party shall be entitled to. The word shall is in the statute. It's not a hearing. The issues don't get decided. There's no mandatory final rulings or findings, but it will do something for the board that I would respectfully submit to you. It's custom made for this particular set of issues. It will give you the opportunity to have one or more people if you want to preside over a conference where the parties can work towards resolving some factual disputes, narrow issues, identify what the legal issues are, that delve into some of these orders and language, and then make a recommendation to you or make a summary to you that would assist you in your formal English. But that's how we got here. And one other thing, I'll let Mr. Pruitt talk, where I'd be glad to answer questions. At the conclusion of the telephone conference that we did 3 hours, parties were asked and agreed to submit legal memoranda about legal facts. And so we did that. We drafted basically a brief. It's not really a brief, but it's 15 pages, but it's a long document. And we set forth in there lots of issues and lots of factual intentions that went well beyond those initial 2 objections. So all of that is on the table. It's not just the first 2 that we saw at the outset of the case. So, number 1, we think we're entitled to an informal conference. And number 2, and the alternative, but we definitely feel strongly about that. If you overrule us on that today, it's not, we submit to, it's not fair to require the parties to go forward with formal hearing. Because we just found out we might have 8 days ago, and it doesn't even say we will, it says might possibly. So that's not really the notice required. If you have any questions, we'd like to answer them. Otherwise, I'll let you.
I was, Mr. Chairman, as I've stated on the record, represent the Camden Energy Company. They're the gas on pole. Large part of the surface on each track. I was also in that telephone conference. And I agree with Mr. Street's analysis of that conference. I want to read you the lead-in paragraph in brief that I prepared.
We've all been privy to the minutes that came out of the last conference. I don't know whether we need to carry that today.
I'm not going into authorities. I just wanted to point out, if you'll allow me, that because this is prepared in anticipation of an informal conference, Camden Energy does not waive the right to future authority. So clearly the documentation supports what we're saying. We were opting an informal conference. That was my understanding also. At the conclusion of that, that though he didn't like it, Mr. Schwartz also agreed to submit authorities for an informal conference. On the 13th, so we participated in that. Yeah. It's a little bit surprising that he would have just used this stuff.
Just a point of clarification here, items 6, 7, and 8. You're rolling those into items 9, 10, 11, and 12 under the same objections. It was my understanding that the conference that was held was addressing 2 applications by each party that were competing for the same. The other 2 applications had different objections filed, and those have been written.
The original objections were granted. So it's original ones filed by Mr. Street. However, my objections to all of these applications are consistent with what is in the memo. We had the same issue.
That's an interpretation that this group can weigh in on. We've had some of the discussion we had in the closed session, we'll address that it was unclear as to where the objections were at this point in time. It seems like this issue has now been cleared. Is that your opinion also, this evening?
In fact, one of my correspondences referenced the other numbers.
Yes, they all have the same continuing objections. It's the same subject matter.
So, based on this discussion at this point, during the closed session, the board had extensive discussions on how to handle these issues going forward. It seemed to be that all 7 of these issues need to be addressed in the same one. Yes. Does everybody agree to that? Maybe Mr. Schwartz does not, but.
Well, I'd like to respond to Mr. Street's comments about how we got here. It won't take long. I have 4 points that I want to make. This whole exercise about whether or not we should have an informal fact-finding hearing was not my idea. I am not sure whether or not it was Mr. Street's idea or Mr. Pruitt's idea, but we wound up not being requested, but basically being told by the AG we were going to have an informal hearing and a pre-conference. I feel like I've been along for the ride here. During that 3-hour meeting, because we have been holding formal hearings for 35 years in front of this board, I said, there's got to be an exemption from the informal fact-finding hearing as some kind of a requirement. Otherwise, we've been doing this wrong for 35 years. And I was told there's no exemption. Subsequent to that, I did some research and I've shared my research with you all and I've shared it with the lawyers on the other side here. And I think this, well, to make it real short, the 1990 Act created the Virginia Gas and Oil Board. We didn't have one before that. It gave you your duties and it told people how do you get a hearing and what kind of hearing you get. And it says, the statute says, if you want a hearing in front of the board and you're an applicant, you need to file an application, give the hearing date that it's going to be heard. The statute goes on to say the board's going to hear those things. The board is going to enter an order, and there's nothing at all about an informal fact-finding hearing. And so my position is, yeah, I got dragged along for that ride until I had a chance to do enough research to realize it was a detour and not something that we needed to do. Now, with regard to this, so that's point one. With regard to actual notice, we've been trying to have a hearing on G39, which is the first one here, since June. It got continued in June. It got continued in July. And here we are in August, and they want another continuance. So we're looking at, they've successfully continued this thing, kicked it down the road for 60 days. Now they want to kick it down the road for another 30 days. How could they not possibly know we wanted a hearing today? We gave them notice of a hearing. It's been continued. It was set for today. So this actual notice thing is just inconceivable to me. Then, third point. I submitted my position on all of this stuff on August 15th, along with some other things. I sent that letter to opposing counsel. I sent it to Mr. Skarupa. I should assume he has, circulated among the board. I mean, I went through their stuff that they filed and I responded. And I've got a laundry list of things that I don't agree with. So if they're unsure of where I'm going to be coming from, if we have these hearings today, which we should, I told them on the 15th, and it shouldn't have been a surprise to them anyway. And then my fourth point is the question that the chairman's been asking. Their original objections, as I recall, were three things. One, notice. Two, was, I think there's an argument about titles. I haven't heard anything about that. Those things have been resolved. They're not issues anymore. So, the stuff that we were talking about, some of the things we were talking about at the hearing, there's no point to them. Everybody's got more than 30 days notice. We've been continued for 60 days, for goodness sakes. So I would respectfully request that we stop kicking this can down the road and we have a hearing like we always have, because that's consistent with the Virginia Gas and Oil Act, and we get moving here.
For the record, Mr. Chairman, the title issue is still very much alive.
Sorry. I didn't hear that.
For the record, the title issues are still very much alive. Those have not been resolved.
Okay, well, let's fight about them today.
May I respond, Mr. Chairman? I'll be brief.
Yes.
The insinuation that we should have known there's a formal hearing today and that noticed is without basis whatsoever, because here's why. On July the 30th, here's what we were told at the end of our informal conference. So on the 19th, this is from the Attorney General's office, with the division director on the phone. On the 19th, the proposed actions to the board will be inclusion of the contrary petitions, that's the competing petitions from Diversify, in this informal fact-finding proceeding, as well as voting on a short order or de novo appeal from the informal conference with formal hearing. it probably won't be called de novo, but an automatic right of appeal essentially from the informal fact finding proceedings to the later formal fact finding proceedings. In these cases, they'll specifically appoint a hearing officer, and then based on that, we will determine when the informal fact finding proceeding will occur. So there likely will not be an informal fact finding proceeding on the 19th unless they appoint someone in the room or something to be the hearing officer. That's what we were told. That's the notice we got from the division on the 31st. That's the notice we had until August 8th. Yesterday, 6 business days between that day when we get a new email. That's the number of days we had to think maybe we're not going to have a formal conference. Even then, someone told us we were going to have any. So it's not fair to suggest that we should have this when we are totally explicit from the Attorney General and the division supervisor on the phone. They're not having a formal hearing on August 19th. That's what we believe until tried before. So that can't be adequate notice. That can't.
Well, I wrote to everybody on August 15th and said, by the express terms of the 1990 Virginia Gas and Oil Act, the IFFH process does not apply to pooling petitions and or other applications filed in notice. And then, I mean, how could you not understand? You might not have agreed with that, but I was telling you, I was looking forward to a formal hearing. I wrote again on the 18th to you guys and everybody, and I talked about the Gas and Oil Act and that it requires formal hearings. So you may not have liked what you were hearing from me, but I was telling you, we've noticed this for a hearing, these applications, and we think they're going to be formal hearings and we're going to be ready to go. And the other thing I need to tell you is the only people that can tell us what we're going to do at a hearing is the board. And you keep saying the AG told you this or told you that, and assuming you're accurate, let's just assume that for the sake of argument. The board didn't tell you they weren't going to have a formal hearing today. I was telling you I was going to be asking for one, and I don't understand why you're surprised.
At this point, during our closed session, we had a lot of discussion on formal hearings versus informal hearings versus regular board hearing. I can ask Ms. Cooper to summarize that, or I can try to summarize it. And that will probably make it a little clearer as to the decision that we're going to render today. How best do you want to proceed there, Ms. Cooper?
Or I'm happy to summarize, and if the board or anyone catches anything that I did not say that is relevant, please feel free to chime in. I pull up the code sections here. So as you all know, the Virginia Gas and Oil Board conducts its hearings pursuant to Virginia Code 45.2/1618. Specifically, we're looking at provision C. And within that, we are looking at the first sentence of C, which says, the board shall conduct all hearings on any application made to it pursuant to the formal litigated issues hearing provisions of the Administrative Process Act. Now, the term formal litigated issues hearing provisions in and of itself on its face does not necessarily require formal hearing at the offset. The Virginia Code in other areas that require formal hearing will state the term formal hearing, and then we'll cite to the Administrative Process Act 2.2/4020, which is specifically the formal hearing requirement of the APA. Here, the waters are muddied, so to speak, because the hearing requirements for the board are pursuant to formal litigated issues hearing provisions and cites the APA generally, as opposed to requiring explicitly formal hearing and pointing to 2.2 Now, next in my analysis, so at the offset, any inconsistencies in this language and referring us to the APA generally would have us go to informal fact-finding conference first and then formal. As of recently, we've had many APA experts in the APA's office weigh into this, and they've drawn my attention to within the APA, Virginia Code 2.2-401, which is the definition section. And within there, the term hearing refers to agency processes other than those informational or factual inquiries of an informal nature provided in this code section that doesn't apply to us, but including 2.2-4019. So when we go back to the enumerating statute for the Gas and Oil Board, which uses the term formal litigated issues hearing and then cites the APA generally, we use the APA general definition of hearing, which in turn seems to exclude informal fact-finding proceedings. Now, my recommendation to the board was that, first of all, this is clear as mud, but that this definition of hearing under the APA seems to indicate that the General Assembly more so intended there to be a formal hearing rather than an informal hearing for the Gas and Oil Board. So this is a recent development. It's gone through many layers of analysis over time, and that is why, it has changed over time, and the board will need to be the one that makes the decision as to how to interpret that. Did I miss anything, Mr. Chairman?
I think you covered it very well. Skipper, thank you very much.
Thank you.
But based on that discussion that we earlier held, the motion before the board today is the board will hold one formal hearing for the agenda items 6 through 12 and will designate Director Phil Soroka the power to issue subpoenas pursuant to Code Section 45.2-2022. The formal hearing will be held on a date to be determined by the parties involved, and we can discuss that after this motion. Each party will summarize their matters of fact and law asserted by the memorandum in advance of the hearing on such and such a date. And we'll set that date also for those summaries and provide a copy of such memorandum to the board with each other party by then. So that's the motion that the board would like to make today to address these items, and I'm seeking a second from the board on this motion. Second. They can told the board, please.
Mr. Owens,
Same.
Mr. Harris,
Yes.
Mr. Jansen,
Yes.
Mr. Mullins,
Yes.
Mrs. Gibson, and Mr. Cochran.
That carries the motion. So I assume everybody here understands that this board will hear these items in a formal hearing setting. The date, which we can discuss at this point in time, if their priority would be to, if possible, hold it on the same day as a regular scheduled hearing. That means everyone's schedules. We can do that the next hearing in September. We do have a notice here that needs to be made, but I think all the parties are here. If we think we can solve the notice, everyone's in agreement with that. Here, you need to discuss it on the notice.
Mr. Chairman, thank you for the clarification. That's all we have. That's all we ask.
So do I hear any discussion from the parties involved on the date we want to hold this hearing? This hearing will be held separate from a regular board meeting. It'll be open to the public, just like the regular board meeting is going to be conducted separately from the regular board meeting. It will be a formal hearing. And my understanding is that after that hearing, the board will have a time frame, obviously 30 days to render a decision. That decision will be divided into both parties and then can be an appeal process if that. So
Mark, you're muted.
Can we have the hearing on the next board date, maybe in the afternoon? Have the usual docket in the morning and hear the special in the afternoon, so everybody doesn't have to make 2 trips?
That would be preferable. Well, we can schedule them and then have the regular hearing. And then depending on how we present that hearing, we can go directly to the formal hearing, or we can have a break and then go into it. If all the parties here are in agreement with that date.
That works for us.
That's scheduled for September the 16th.
Works for us.
Mr. Chairman, I have a board that I represent that has a meeting that night. And school board meeting. In Gander, I wish Trinity is the one that covers that. That's fine. I don't want to give her up. Kind of need her, but so really we don't have a cover for that. I can probably ask someone else in my firm to be totally candid with you. I can probably get it done, but I would suggest this. I don't know how long our hearings. I have witnesses with arguments. So, I go too late in the evening or flip to the next day. It might be wise. The whole day, like the next day, for example, 17.
What are the parties are going to be involved? Any other discussion on the schedule date?
Cameron Energy will be involved for the judge.
Let's hold on schedule that day. So the other part of this motion was that each party going to summarize the matters, the factor law, sort of about a member in advance of the hearing. So how much time does each of the parties, we've been through this for several months now, is there a need for a lot of extended time? Takes this September date unworkable for some people, or is that date in September for everybody to get their summaries in ahead of the meeting?
I suppose if you required people to exchange their memorandums 7 days before the September hearing, that ought to be fine with me anyway.
He sounds like he's good with September 16th and 17th, which is one of those days. Will there be any concerns by any parties? Does anybody anticipate depositions of witnesses prior to this, because this is a formal hearing, or will there be cross-examination? So is all that doable before the September vote?
Well, normally, I could finish 5 hearings in an hour and a half, okay? Because a lot of the information is recycled. I'll do a thorough job on the first one, which will take care of, a couple of long wall panels and other issues that would come up in the next series. But I think, if we want to be efficient, we ought to be able to finish this in a day. Now, can we finish it in 4 hours in the afternoon when they're telling us they got 5 witnesses? Maybe not. But I mean, we ought to be able to finish this if we start at 10 o'clock in the morning someday, maybe the next day. Although if we start at 1 o'clock in the afternoon and I take an hour and a half or 2 hours, they're going to have 3 hours to get to 5. Wouldn't that possibly work?
That wasn't exactly a question you asked. But I think the question you asked was a smart one. So we may actually, I can tell you that we almost certainly will want some subpoenas. We may also need to take the deposition of a corporate witness for Pocahontas Gas, because now there's some concern that routine witness that they call, they may not have all of the information. So with a little more consideration based on the question, that might mean we need to do it. Talking about 17th. Maybe the 23rd or the 30th, that would be the spot. The 23rd would, you're saying no? 10. 30th? That's six, that's basically 6 weeks in one day. And then, that's the last day of September. And 30. On the briefing, we'll probably have most of that done. This time around, if possible, we have a few days between our receipt of Mr. Schwartz's proof and ours. That way we can respond as once it sees the applicant on some of these. That's the word. We went first last time.
I don't care who goes first, I just want to go.
Excellent.
Why can't we do it the 17th?
I think that would be the preference of the board to do it on the 17th. We could work that out. Bring in the board. That puts that on.
It's still on the dock.
Yeah, I'm assuming that.
Well,
16.
The 16th,
How much stuff's already on the dock?
4 items so far, or is it
I think we got time.
5 items? So,
And the deadline's passed, right?
That's good to say. Some of those items are going to be involved with, say, the issues we're having today that have been filed by Pocahontas.
Probably.
So assuming that we just continue those items until we had this formal hearing, we would be able to start a little earlier. We could even start at 9 if everybody wanted to. Make sure we get it right.
16th.
Yeah, 16. 16.
Whatever your preference is in that regard, Mr.
Okay.
Chairman, but I think the 16th or the 17th would be, a good, everybody should have the 16th available. We need to take advantage of that. And in terms of people who travel, if we're going to do 2 days, the 17th makes a lot of sense. But, I'll leave it to you as to what we hear.
I just want to be fair to all parties here, that they feel like they are given enough time and to get everything together, and we have enough time to do the hearing.
Do you have that board meeting on the 16th? You have at least 3 different parties that reacted to the case. At least one of us is long-winded. And so, 17th, if we have to go that same, you did sort of convince me that we need another couple of weeks because the discovery aspect. So that's why I would be more in favor of staying for the jury session. 24th would be an option.
Why can't we do the 16th or 17th?
everybody on the board have any objection to the second, if we started a little earlier over 16. Recognizing the fact, I mean, I guess there's no reason we can't do the formal hearing before the regular board meeting.
Correct. We could do that, and that would make some sense, I think.
Yes. It makes sense to do the regular, do the formal hearing first. And then based on that, you would know how to proceed somewhat.
Great
on
idea.
the-
Great idea. That works.
Figure it all on 16. I thought you meant this.
That's not what I meant to say. I have 6 o'clock.
So we started 9 a.m. on the 16th. Do you think?
Yeah, I can get back. That's not a problem for me, but y'all are better at this time on the news before, but,
We're just trying to accommodate all
it
parties.
seems unlikely that you do the hearing that day before your,
Well, that's why I said, we would do the regular board here after the form. We
Yeah.
start with chicken.
you're straight, you're gonna get pinched on time.
Well, we're gonna be pinched one way or the other, then we'll have to continue either way. Even if this is another day.
Yeah,
I think you have an opportunity to be together already on the 16th, right?
Right.
Can we go ahead and agree to schedule the corporate deposition of Pocahontas West designee on the date of serving, so that we know we'll get that in before the 16th, that's what it is, so.
Do we really need to do that in front of the board?
Well, if we're looking at 4 weeks, we're gonna have a hearing and, a better time than now to go ahead and iron it out so we don't end up having to fight about this, go back to the board and start from it. Just trying to get it all set up so you don't have to worry about the details.
Well, let me give you an example of why we can't do it. We don't have the person you want to depose at this meeting, probably, and that man or woman probably has a schedule. So, do you know who you're going to depose? If so, who is it? And if they're not here, do we have to get them on the phone while the board waits?
If it's a corporate designee, you get to decide who the person is. I just give you the issues.
Well, depending on what you ask for, it's going to determine who we provide. So what are you going to ask for?
I'll give you the list. Give you a bullet point list of topics.
And then we have to confer to figure out who's the witness that could address all the issues that you want to take into consideration at a hearing. And we're just wasting our time and the board's time. Let us know what your topics are, or get us a subpoena, which designates the topics that you're interested in. And we'll look at that. And to the extent it's appropriate, we'll get back to you. We got 28 days to schedule one deposition.
I'm happy to do that. I just thought it would be short. That's fine. I thought you understood what the issues and facts were already. So I'll send you a document. It's fine.
Okay, so we in agreement that we will convene the formal hearing on September the 16th at 9 a.m.
Right.
Meetings for me.
Yeah, I do have one thing to mention on the 16th, this room is not available on the 16th. But we will get a room already scheduled since we have a board meeting that day. We already have room reserved in NECC down in the Phillips Table Building. We do have a location there. It was just this, we wouldn't be having this one, but it's right here adjacent on the property.
Works for everyone. I can also get a room courthouse through Bradley. Not to make my board meeting.
Always for Sarah, send everybody, send everybody with the room numbers and the location. And have that the room is large.
So don't say that you didn't nail down was what the day everyone would have their meeting in is in on prior to this hearing on 16th. You know, that date down, and if that will get crossed, you know, so it depends somewhat on your subpoenas and your transitions. Make sure. I mean, as quickly as you can.
Here's the last thing he says.
I said that, through those, all those memorandums that come in summarizing those positions ahead of the formal hearing. That may depend somewhat on your subpoenas and your deposition, if we need to get in place. So, if you look at the hearing on the 16th is. What does the board need more than a week? They say. Well, September 9th. Okay. Shoot for that time, please. We start running the problems and we'll have to fix it.
So the question, Mr. Chairman, we have a time, regular meeting on the 16th. Or do we need to cancel it?
Well,
You had one other docket item?
you know, the other was, it's not the same as.
No, it's T-Rock, Kennedy.
Nothing. It should break in.
Yep.
It's already pulling.
We grew.
Yeah, I think you, that,
Yeah, that's how long this, how long this would go, and it may, the only reason to do the formal hearing first was that this clear path to with the other board. But it sounds like no matter what, that we're probably going to end up with another formal hearing, I guess, in those 4 hours, unless the parties still be for them.
Mr. Chairman, Mr. Chairman, point of clarification. When we submit our memos, will Mr. Schwartz submit his before hours so that we can respond? Didn't happen last time.
I'm not, I don't know what the procedure is there. Ms. Cooper, can you weigh in on that? How is? Is there, they just submit them by the. It's 9th. Was there a response after that? Did you work?
There is no specific regulation speaking on it, so it's whatever the board would like in this instance, Mr. Chairman.
Really, the only thing I'm asking, Mr. Chairman, is if Mr. Schwartz raises something novel in his response, if we do it about his response the same day, you can't address it.
Again, you're getting the legal topics that are beyond my comprehension here at this point. It's, we're asking for summarizing both party positions just prior to the hearing. Okay. So I don't know if there's a need for a response from either side. You summarize, the board will hear from have the have something to go on for.
That's fine. So we,
I'm fine with that too. I would add this one thing. After the conference call, we had the lengthy call. We did a three. And we raised a bunch of issues in there, like Oakwood 1, Oakwood 2, what's where other all stuff. If we're both, I just want to make sure Honest Gas is going to have a chance and at least a perceived obligation to address those legal issues. What I would be discouraged by is if Honest Gas is free, it just doesn't address any of those things. It says we filed a permit and our application with cross it first and we have to all evidence and we win. And then, you know, we don't have the benefit of,
We were pretty, this will be a unique hearing in front of this board, who once never heard, so I think there will be the opportunity to cross-examination. So I think that should be, maybe some of that, should have some opportunity to have questions, some witnesses, address issues, and not take a good boss group. If that sounds reasonable, I'm not sure how that is going to come out, you know, we're here wanting to see what happens from the first one.
yeah, I think we have the same goal, which is what we had before, which was put much of our cards on the table. We got a hearing officer, but the board has all these issues and we're going to know a lot of stuff, see that. And, I guess, Pocahontas guess doesn't have to be that if they don't want to, just, we both have to agree, but.
You know, I don't know what you're talking about in terms of us disclosing stuff. I mean, the board has by rule told applicants what they're supposed to submit with their application. You're supposed to submit a plat, tract IDs, exhibit B of all the owners, exhibit M with regard to dollars and cents, and so on and so forth. I mean, we submitted all of that stuff that we were required to submit a complete application to be heard. So, you know, basically the rest of what I've had to deal with is the myriad of defenses that you are claiming you have to my application. So, I mean, I followed the rules and the statute and filed what I needed, a complete application that tells you, here's what I have in mind for these units. And I'm perfectly content to file again a summary that says what I think about all of the myriad of issues that you have raised in defense. But to say I didn't tell you what I had in mind, I did that in May when we mailed this stuff out. But I'll put in writing, I'm relying on my application, and with regard to the offenses that I'm aware of, this is my reaction, although I've pretty much already done that, but I'll do it again. And I think a week in advance of the hearing is fine. To me, this is something that everybody's been doing for years and years and years. This is no longer rocket science for people who are familiar with the process.
I'm not surprised at the answer I got, but if there's more to possibly, we'll just have to deal with it, I guess. I'll see them. Do the best for them. Do you have any other issues that we could with more before we move on?
Yeah, Mr. Chairman, this last thing, since we're having a hearing, why did we not just cancel or continue items on the agenda for the 16th, move that to the following meeting? That way that day won't be affected by how long it takes to put this.
I'm fine with that.
So just, that'll be a matter of the record, and that'll be moved forward just because the meeting is produced.
Guess the staff will take care of that in the notice. Yes.
Do you need to hear the board say that?
Do we need a motion from the board to continue the
Yes.
the meeting?
Yes.
That's very good.
I'll go ahead and make that motion and then continue the items potentially or originally scheduled for September 16th. We have to go to be continued for 30 or till the next week.
Yeah, I'll do it in a second. Whole board, please.
Mr. Owens?
Yes.
Mr. Harris?
Yes.
Mr. Jansen?
Yes.
Mr. Mullins?
Yes.
Mrs. Gibson?
Yes.
And Mr. Cochran?
Yes.
In case anybody's interested, it's October the 21st, it's their Tuesday.
Okay, anything else from the parties on items 16 to 12? That's what people. Mr. Chairman.
No, sir.
All right, item number 13 on the docket is the board will receive and update for the board and division activities of the staff.
Which is pretty well done. Yeah, thank you, the name of the board.
Report there. So item number 14 on the agenda. The board will review the July 2025 minutes for approval. And all the members of the provided and that is,
Motion to approve.
second. We vote, yes, verbal vote for approval. All in favor, say yes.
Yes.
Yes. All opposed? Approved. That concludes the meeting for the Virginia Gas Noel Board hearing on August 9th, 2025. Thank you all. You as well.